No? Okay. Good morning. Welcome to USJI seminars on the seeking for an effective framework of international legal order in the Asia-Pacific regions. I'm Katsuichi Uchida, the president of this USJI, and also the professor of law at Waseda Universities. First, let me introduce USJI. USJI is a non-profit research organization here in Washington, D.C., established in April 2009, and currently managed by 9 leading Japanese universities, namely Dosha, Keio, Kyoto, Kyushu, Ritsumeikan, Sophia, Tsukuba, University of Tokyo, and Waseda universities. And USJI is financially supported by Japanese business societies. The missions of USJI are to promote policy-related research at our member universities, to organize research teams, dispatch their research results to the wider communities by the medium of English, to nurture young researchers relating U.S.-Japan issues, and to formulate a community of researchers and policymakers. And USJI for the week-long seminars twice a year in March and September, and occasional seminars here in Washington, D.C. We also hold symposiums in Japan. With regard to the details of our activities, please visit our website. And this week, from today to Tuesday next week, we'll hold 9 different events covering a wide range of topics. Please see the schedules of USJI week. And I hope that you are able to participate as many as possible. And this morning, we'll have a seminars on seeking for effective framework of international legal order in the Asia-Pacific regions. With regard to the purpose of this session, please refer to our abstract. We are very fortunate to have 2 distinct speakers on these important issues. I'm quite sure today's discussion will produce fruitful and productive result and become the foundation for the further discussions. Before introducing today's moderator, Dr. Ellen Forrest, and to speakers, I need to receive your permission on being videotaped. And the videotape will be public, or open to public through internet. And when I receive the permission, thank you very much. So let me introduce Dr. Helen Forrest, please.
Well, thank you very much, Uchida-sensei. I feel extremely honored to be asked to moderate this session, especially one on such an important topic that's been on our minds in Washington, D.C. I will not repeat the biographical information that was given to you, other than to say we have 2 very distinguished speakers. As you can see, Professor Furuya is a professor of Waseda Law School and also Dean of Academic Affairs at Waseda University. So he has his hands full. And is sharing his thoughts on international law with us this morning. Commenting on his presentation is Peter Truboff, who for many decades, I won't say how many, has been practicing international law and is also a senior counsel at Covington and Burling, one of our most prestigious law firms. So I will merely reiterate what President Uchida just said, which is that unless anyone objects, we will assume that you are willing to be videotaped. And this whole session is on the record. There is no restriction on anything that anyone says. So with that, I'd like to turn over the meeting to Professor Furuya. And please proceed.
Thank you very much, Dr. Frost, for your kind introduction. Ladies and gentlemen, very good morning. It is a great honor and pleasure for me to have the opportunity of making a speech before distinguished participants. I'm not sure that the microphone is working or not, but my student often said my voice is very big, and sometimes said that my voice has no volume tuned, and so the 0 or maximum. So I would like to speak to you in maximum volume. So the topic I will discuss today is the legal framework in the Asian Pacific region. In the last several decades, the alliance and the cooperation between Japan and the United States has substantially contributed to realizing the stable international relation in the Asian-Pacific region. This region does not have any particular organization like European Union or African Union to prevent conflicts, settle disputes, and stabilize economic situations. But the presence of the United States with having a strong political and economic and military tie with Japan has played an alternative role for those purposes. However, the situation is rapidly changing with the rise of China. China is emerging not only world's second largest economic giant in terms of GDP, but also super military power, having a strategy of increasing its presence in South and East China Seas. While most of the countries in Asian-Pacific region have strengthened the economic relation with China, they also increase a sense of caution in the face of actual or potential territorial dispute with China. It is sometimes pointed out that much of the philosophical outlook of the Chinese government is still rooted in the cultural tradition of imperial China. The historical mindset of the Sinocentrism was that China was the center of all civilization, and its smaller neighbors must exist to give tribute and pay homage to the emperor. Therefore, the international order that Sinocentrism provided was completely different from the current international order originated in Europe, which is based on the sovereign equality of countries and conducted by rules of international law. In fact, some international lawyers have observed that the very essence of China's land reclamation and the militarization of the South China Sea is not merely the problem of the access to resources and the security of vital sea lines of communication, but rather than the future of international order. So according to them, by insisting maritime and the territorial rights over the entire South China Sea, China is in effect challenging core principle of international law enshrined in the United Nations Convention on the Law of the Sea, UNCLOS. This makes them to consider that rising China is pursuing the prominence in global status in order to revive the traditional order. I do not think that this interpretation wholly describes the basis of the current diplomatic policy of China, but at the same time, I also consider that there might be the possibility that China would have different image of a regional order of Asian-Pacific area and give preference to bilateral political negotiation over legal multilateral solutions, even though it does not fully challenge the application of international law. The opinions often held that as compared with the countries of Africa and Latin America, the East Asian countries have declined to rely on international law to settle international disputes. And in particular, it is quite rare that Asian countries have submitted the territorial dispute to international courts, like the International Court of Justice, ICJ. In general, the trend this opinion points out is true. However, we should also take into account two territorial disputes concerning the small islands which were recently submitted to ICJ. One is the case between Indonesia and Malaysia concerning the sovereignty over Ligitan and Spadan Islands. And this case was taken in 1998. And the other in the case between Malaysia and Singapore concerning the sovereignty of Pedro Blanca in 2003. It is generally evaluated that ICJ's judgment of these cases created a win-win outcome, and that the countries concerned was improved their bilateral relations by this judgment. The very important is that the submission to the ICJ in these cases were made by the special agreement between the parties concerned. It is obvious that the parties share the common understanding that they should settle their dispute by relying on international law and undertook to comply with the judgment by the ICJ. This fact indicates a general tendency among ASEAN countries to settle territorial disputes through international law and judicial organs. And in this extent, the rule of law in international relations has been gradually accepted in the Asian Pacific region. Bearing such a tendency in mind, a quite recent case between the Philippines and China concerning the territory over the Spratly Islands in the South China Sea is quite interesting and valuable for understanding the attitude of China toward international law. So according to the UNCLOS UN Convention of the Sea, when a country becomes a party to this convention, it provides consent to the dispute settlement provisions, according to which if dispute arises between parties on the interpretation or application of the UNCLOS provisions, and dispute cannot be settled by a consultation and negotiation, either party to the dispute may unilaterally bring the dispute before international court or arbitral tribunal. A party to UNCLOS has a right to elect its preferred forum for the resolution of any dispute. However, neither China nor the Philippines has made a declaration indicating the preference for the particular court of tribunal. The Philippines, therefore, instituted the arbitral proceedings against China within the framework of the Permanent Court of Arbitration located in The Hague, the Netherlands. China, however, refused to accept arbitral proceedings and actually did not appear before oral hearings on jurisdiction and admissibility, which was held in last July. The non-appearance of the party before international court is not unusual. What is special in this case, however, is that even though China has taken the position it does not accept the arbitration initiated by Philippines, it has not adopted the complete neglect policy toward the arbitral proceedings. Actually, in December 2014, the Chinese government officially issued a so-called position paper on the matter of jurisdiction in the South China Sea arbitration, in which Chinese government elaborated in a rather detailed argument the reason why it believes the arbitral tribunal does not have jurisdiction. Unfortunately, I don't have sufficient time to discuss the details of the China's argument, but important is that the position paper is a legal document of high quality which refer to many precedents of the ICJ and is substantially equivalent to written pleadings. The tribunal itself considered the communication by China, including the position paper, to constitute a plea concerning the tribunal's jurisdiction. The point I would like to raise here is that China is insisting that disputes should be settled by bilateral political negotiations between China and the Philippines. But at the same time, it is attempting to legitimate its policy on the basis of legal arguments. On one hand, it is obvious that China does not want to settle the dispute through judicial organs. But on the other hand, it does not or cannot rely on the naked power or real politics. What China is doing now is to be called the politics of international law. So this is applied to the Philippines as well. The non-appearing party is still a party to the case and bound by the judgment of the tribunal, whether it agrees with it or not. Unfortunately, however, the UNCLOS dispute settlement system does not provide for enforcement mechanism. This means that should China refuse to comply with the judgment perceived to be unfavorable to its interest, it is unlikely that there can be any legal sanctions against such non-compliance. It is no doubt the Philippines is fully aware of it. Then why did the Philippines venture to use such costly and time-consuming arbitral proceedings if its final award is bound to be ignored? The approach of the focusing solely on the question of how compliance should be assured would ignore the important question of how legal evaluation by a judgment would give an impact on conduct of the respondent country. Political relations between two parties would be different depending on whether the applicant country has a judgment favorable to it or not, even if the judgment is never enforced. The Philippines, in this case, has stated that it regarded the case not as the end of the dispute, but the beginning. What the Philippines seems to be seeking is to create the situation in which China would have to clarify its claims and bring them into conformity with international law. This in itself is only the first step in untangling the South China Sea disputes and enabling the parties to settle the dispute on a fair and equal footing. In dealing with the neighboring country, which is stronger in all aspects, the arbitration is also a way to draw public attention to China's actions and create international pressure on China to reconsider its position. In this respect, the Philippines also invokes international law as one of the means of international politics. Sometimes we are inclined to discuss that the enforcement mechanism of international law is so weak that it does not have any substantial significance in international relations. However, it is not correct. International law has its own way of enforcement. For example, unifying the legal evaluation and labeling, raising public opinion against the violation, and mobilizing a sense of shame. These have some effects on violating countries in the long run. If we do not have any material enforceable power to oblige China to comply with the judgment of arbitral tribunal, the negotiation between China and the Philippines after the judgment would become different from that before it. The evaluation of the international community on the dispute would also be changed. Even if China continued to occupy the disputing area after having lost the case, everyone could openly criticize it as a violation of law. That pressure would ceaselessly give an impact on the diplomatic conduct of China. In my view, China is fully aware of this impact by the Asian inclination to saving face. And for this very reason, it denied to participate in the arbitration, but published its legal opinions. My emphasizing the legal framework does not mean that we should go into strict legalism and attempt to settle any dispute by applying the rules of international law. It is not advisable and actually impossible. Rather, I mean that we should use international law as a tool of diplomacy, and by confining the conflicting countries to a legal framework, prevent conflict from being escalated. So this way of thinking suggests United States and Japan how they should respond to territorial dispute in the Asian Pacific region. Generally speaking, every country is hesitant to make its position clear on the territorial dispute of other countries and feel inclined to keep an attitude of neutrality. This is true for the United States and Japan. I also share the opinion that outsiders cannot and should not say something on the substantial matters of the dispute. For example, on historically, when and who occupied the island in question first. However, procedural matters are quite another problem. In terms of the procedure for settling the dispute, we should not take a neutral position in a passive manner. In my view, it is important for the United States and Japan to send a strong signal to the countries of Asian Pacific region, including China, that both countries are always on the side of those countries which have a clear intention to comply with international law and are willing to submit them to any judicial mechanisms they prefer to. For this purpose, we should take appropriate steps to encourage those countries to adopt a legally binding code of conduct in the South China Sea. Thank you very much for your attention. I would like to have a comment and a question after my colleague.
Thank you very much, Professor Furuya, for your very concise and clear and forceful presentation. So now we'll turn to Mr. Tuba for comments.
Thank you very much. I'm very grateful for the kind invitation to participate in USJI Week. I'm going to speak from notes rather than a prepared text, so I would ask that I have an opportunity to edit or explain if anyone wants to quote from the video recording of what I say. Just 14 years ago, on the morning of September 11, 2001, I participated in an international law conference that was located just across the Potomac in Crystal City, which, as many of you know, sits very close to the Pentagon. We were evacuated from the building immediately after American Airlines Flight 77 hit the Pentagon. I spent the late morning and early afternoon with this country's leading expert on United Nations law, Professor Louis Sohn, and his wife, as the smoke and fumes from the Pentagon circled into the windows of his high-rise apartment. So I cannot speak on the eve of that terrible anniversary without reminding us of that event. I do so not only to memorialize the lives that were lost in New York, Washington, and the fields of Pennsylvania, I do so also to recall the importance of building and preserving an international legal framework that, in the words of the Constitution of the American Society of International Law, quote, promotes the establishment and maintenance of international relations on the basis of law and justice. Dean Furuya has addressed what he calls the politics of international law, with emphasis on maritime disputes and the use of international law as a tool of diplomacy and as a framework for managing regional conflicts. In preparing through emails our talk for today, Alan Frost has asked whether different nations have different concepts of international law and whether in particular China has a different view of international law from other nations. I want to make 3 points in the short time I have here in answering their questions. First, and I shall try to demonstrate this, China has accepted and respected international law when it serves its interests. To use the terms of Orville Schell in the Wall Street Journal on August 29, China has shown that it understands at some level that it cannot operate as an island and cannot succeed in isolation. Second, China presents a challenge because China often sees the role of international law in foreign relations differently from the United States and Japan. And third, there are several strategies that we should consider following in the future to encourage China to join international legal regimes. And there are steps that we should take at the same time to bolster the security regimes that stand ready to prevent military challenges in the region. Let me first mention two more short autobiographical notes. In the spring of 1966, I studied at the Harvard Law School with Professor Jerome Cohen when he taught for the first time Chinese attitudes towards international law. And in 1968-69, before entering private law practice, I worked with the late Professor Roger Fisher, who was famous for his book, Getting to Yes. My assignment was to write with Professor Fisher a companion volume titled Improving Compliance with International Law. While our volume never enjoyed the success of Getting to Yes, it started me on a path of efforts to see international law as an instrument for ordering international relations and resolving international disputes. Thus, it could be said that I've had over 50 years of interest in this subject, although I'm certainly not an expert on Asia. I come to this discussion from an international law perspective and as a private practitioner with over 4 decades of experience advising major multinational corporations, many of which have operations in Asia or are based in Asia. To be sure, China is not alone in challenging aspects of the international legal order that emerged in the post-World War II, post-Cold War world, or in raising questions about certain of the principles that form part of the body of international law. At that same time, many tend to overlook the extent to which China has joined the international system as we know it. Further, this isn't new. Let me give a few examples. When China and Canada normalized relations in October 1970, China pledged in the normalization agreement to conduct the reestablished relations, quote, in accordance with international practice, unquote. Note, the reference isn't to international law, not yet, but rather international practice. Professor Cohen reports that in 1972, a year after China had taken its seat in the United Nations, he had a dinner with Chinese leaders, including Premier Zhou Enlai. They ridiculed the professor's suggestion that China nominate a leading Chinese jurist to serve on the International Court of Justice. However, just 10 years later, a Chinese jurist was elected to the ICJ, and a Chinese jurist has served on that court since that date. In the board of the Hague Academy of International Law, I've worked closely with the current Chinese ICJ judge, Judge Shui. She's a remarkable scholar and holds a Columbia Law School LLM degree. She has a refined and highly analytical approach to international legal issues. Let's move forward to the current period. China was among the nations that negotiated the Joint Comprehensive Plan of Action for addressing Iran's nuclear program. Just a few weeks ago, China voted in favor of UN Security Council Resolution 2231. It will be one of the members of the Joint Commission established by the resolution, and thus it is subscribed to a voting procedure under which it will not have a veto over a finding of an Iranian violation of the agreement or the ability to block a decision since there's no quorum requirement for decisions. On the occasion of the Security Council approval of Resolution 2231, the Chinese permanent delegate to the UN is reported to have emphasized 2 points. First, that the joint plan showed why it was, quote, important to stay the course in seeking a political solution which was the only viable way to address difficult issues, unquote. Ambassador Liu added that the plan was a, quote, good beginning, but that, quote, implementation was more important and that taking stock of good practices along the way was essential. To be clear, I'm not naive. I recognize there are many political and strategic reasons for China's signing on to the Iran nuclear agreement, including investment, energy resources, security, and other interests. But that proves my point. When its interests are served by adherence to international legal process and agreements, China has shown a willingness and even an encouragement for such an arrangement. In short, there's not on the part of China an aversion, if there ever was, to international law per se. So permit me in the remaining time to conclude by turning to some proposed strategies for encouraging China to join international legal regimes that will serve the interests of all nations in the region in addressing common issues and problems. I don't have a magic formula to resolve the many disputes that require Chinese willingness to engage on the basis of international legal principles. I'd suggest 3 strategies that are worth considering and that reflect the role that law may play. First strategy, pragmatism in implementing legal and regulatory cooperation. 2 examples. U.S. Food and Drug inspectors are today operating in China. Of course, they're there to ensure the safe export of products to the United States. But their presence contributes to the safety not only for U.S. consumers, but also for Chinese people by raising standards in Chinese food and farmer productions. There's an enhanced transparency, if you will. Second example, China's concessions on joining the WTO. They were unprecedented for even a developed economy. And the Chinese compliance with recommendations of the WTO dispute settlement body have been impressive. Some even argue, in certain respects, rivaling the compliance record of the United States. So first, pragmatism. Second, reformulating issues, what my mentor Roger Fisher used to call changing the question. In this case, from political to legal. In a thoughtful piece on the Senkaku Diaoyu Islands, Professor Shinya Murasi, the Japanese member of the International Law Commission, has explained that the issues relating to the islands need to be seen as more than a conflict or controversy, rather over which 2 governments disagree. Professor Murasi argues that the issues need to be reframed as a dispute that is subject to relevant substantive and procedural rules of international law. As reformulated, the issues could be submitted to dispute resolution or negotiated on a principled basis. In another valuable study that my colleague Alan Frost has brought to my attention, retired U.S. Rear Admiral McDivitt has suggested that the United States should issue authoritative white papers on the legal issues on territorial rights in the South China Sea. I would ask whether a study of the legal issues might be better addressed by involving a multilateral group of experts who would examine the issues under the auspices of a respected organization that doesn't take positions, for example, the American Society of International Law. Such a study would be comparable to the task forces that the Council on Foreign Relations has used to address political issues. The results would be published and available for discussion. This approach would help to explain positions and force an articulation of a rationale for those positions. Third strategy, patient insistence on the role that international law can and should play in resolving disputes. Professor Cohen refers to the Canadian agreement in 2001 with China for the extradition of a Chinese citizen, Lai Cheng-ji, who was accused of being the biggest smuggler in Chinese history. In that case, a number of other individuals had been executed in China. At the demand of the Canadian government, the Chinese government agreed as a condition to extradition to a number of conditions regarding treatment of the Chinese national upon his return, including no death penalty. In 2012, he was convicted, sentenced to life imprisonment, and his property was confiscated. Roll the clock back forward 3 years. The front page of the New York Times on August 17th of this year, while I was preparing this talk, China is alleged to have sent agents to the United States to convince, some would say force, fugitives from Chinese justice to return to China. The State Department, the news article said, has warned China that such agents of government may not legally operate in the United States. Why should China be doing this, and what should other nations do to encourage different conduct? The New York Times article notes that China has few extradition treaties. It mentions that U.S. officials have offered to assist in pursuing common criminals, but the Chinese authorities have been reluctant to produce evidence. Extradition treaties are a well-established method in international law to permit one government to request the return of fugitives from justice. Such treaties permit confidentiality of information exchange, procedures for arrest and detention, and return. I'm not unrealistic. Extradition treaties also cover only those crimes that both governments agree are criminal acts, the so-called double criminality requirement. So the treaties can exclude offenses that one government doesn't accept the other has. Further, the treaties can include limitations on the conditions of return, such as the absence of the death penalty. I'm talking about, for present purposes, what I call real criminals, where there's no real dispute about the charges being politically motivated. For example, those who embezzle funds from businesses or government entities, or who have committed physical crimes causing death or injury to others. No government can ignore this problem, and all have an interest in cooperating to prevent the fugitives from escaping. Otherwise, you have them in your own country where they may engage in the same kind of mischief. I had a personal experience with this issue 2 decades ago when an Asian government had precisely this concern, even though there was good reason to believe that the Senate would ever approve an extradition treaty. In that case, the United States and the government negotiated an extradition treaty and just held it. The very act of negotiation of the treaty, even though not ratified, had a strong deterrent effect in future years in keeping bank robbers and the like from coming to the United States to hide. The recent New York Times article strongly suggests that China should be exploring extradition treaties with the United States, with New Zealand, Australia, and Canada. International law should be seen as an instrument to address a problem and bring about change on the basis of mutual interests. Of course, such an agreement would only work if both governments were prepared to be transparent with each other and meet international standards for evidence of criminal activity. China would need to be persuaded that as it has been on other issues, that there's a well-established practice in which it should participate. In this instance, sharing evidence that remains confidential and does not interfere with future prosecutions. Just one more word. I use extradition as my example. I could equally have focused on the front page of the Washington Post just a few days ago, August 31st. There, the article focused on the proposed unilateral sanctions against certain Chinese parties as a result of those parties engaging in 3 types of cyber theft, specifically attacking critical infrastructure, disrupting major computer networks, stealing and benefiting from misappropriated intellectual property or trade secrets. The Post story makes clear the United States is planning on unilateral financial sanctions. I've spent over 40 years advising on economic sanctions. Trust me, unilateral U.S. sanctions may have some impact, but they almost never achieve the U.S. objective. Further, the unilateralism often leads to U.S. controversy with the allied nations whose cooperation is necessary to achieve the very policy objective in question. And in this case, such sanctions will also probably lead to retaliatory actions, not modified conduct. Again, China will soon reach a point when it will not want to be part of have anything to do with cyber theft. It'll want to protect its own intellectual property. We should be talking about reaching agreement on a multilateral approach to cyber theft. And I could pick as a third example the China-Philippine arbitration, which I'm happy to discuss during the question because it also seems to me to show a Chinese focus on international law. Let me conclude with one other idea because I think it's important and because it isn't international law agreement as such, and that is, and it doesn't involve China as such, and it goes to the security situation in Asia and responds to real concerns about maintaining the defense framework through international agreement. As many of you know, the United States has entered into, and the Senate gave its advice and consent in 2010, to defense trade cooperation agreements with the United Kingdom and Australia. In a word, those treaties permit, without specific authorization, as licenses or approvals, the export or transfer of certain defense articles and defense services controlled under our international traffic in arms regulations. And it allows them between certain persons in the United States and the United Kingdom under the UK treaty, and between persons in the United States and Australia under the Australian treaty. The State Department has now implemented these defense trade services treaties by amendment of the ITAR. Some complain the regime is still too restrictive, but it is an important improvement and provides a framework for further facilitating defense trade and building better regional defenses. As others have proposed, the United States should consider entering into a defense trade cooperation treaty with Japan. Further, if such a treaty were negotiated, it may be time for the United States to consider a multilateral approach to this issue with a number of close allies to avoid extraterritorial controls on re-exports of defense articles and services. This proposal is, of course, consistent, I think, with developments in Japan that would reinterpret Japanese law to permit limited uses of Japanese defense forces in support of its allies and for humanitarian missions. This evolution in Japanese law is highly important and is being closely watched by all interested parties. It is also a complex and delicate subject that needs careful study and explanation. I'm sure that some of you will question or raise objections to some of my proposed strategies. My years with my mentor, Roger Fisher, taught me something important. It's always better to have tried and failed than not to have tried in the first place. So I look forward to your comments, your corrections, and your criticism. Thank you.
Well, thank you very much, Peter. Both presentations were just outstanding. While you all are thinking of questions and comments, I'm going to take the privilege of the chair and throw out a couple of remarks and one question each for our speaker. Since we're talking, Peter, about personal experiences, my first job in Washington was working for Senator Alan Cranston, who believes strongly in international law. We worked to get a particular dispute that the United States had over some tiny island in the South Pacific referred to the ICJ, and it was the first time the Senate had gone on record in a resolution as favoring this. This was a great achievement. Nothing I've done since then, I think, contributes so directly to peace. The comments, I think, about sanctions, I couldn't underscore more heavily. I have myself been in the past in private sector groups. There is a publication from the Institute for International Economics, now called the Peterson Institute, which traces case by case the application of sanctions all the way back, Gary Hofbauer, all the way back to World War I. And as Mr. Truboff just said, the record of achievement is extremely spotty, and the record of unilateral sanctions success is poor. It's a feel-good option and nothing else. The questions I have for you are really two. Professor Furuya, I congratulate you enormously on clarifying that China's approach to international law is neither the traditional Middle Kingdom nor, you didn't say this, but I think you would agree, nor the system of domestic law in China, which is so, controlled so tightly by the party. And I think the nuances that you've expressed are very valuable. My question is that you have recommended that the U.S. and Japan should not remain neutral on procedure, in fact, should cooperate more on this. What is the current status of, if any, of U.S.-Japan dialogue, coordination? Is there a group that meets formally or informally? Should there be a group, a U.S.-Japan group? Should we do more together in this area? That's a question for you. And for Mr. Truboff, can you say something about the U.S. record on international law? The Chinese are always accusing us of hypocrisy, pointing fingers at them and not living up to our own rhetoric. Are we actually pretty good, would you say, on enforcing not just WTO but other cases?
Thank you very much for your question. I'm not so familiar with the diplomatic action behind the door, but as far as I know, that there is no joint action or something between Japan and the United States to give a clear signal to the China and something to comply with the international law concerning the territorial dispute. So each government, of course, Japanese government, the American government, send a signal to comply with international law in settling the dispute between Philippines and other Asian countries to comply with international law. But it is a little bit hesitant way of expressing. So the United States cannot intervene in the substantial matter in the territorial dispute. So instead of that, we just mentioned international law is important to deal with this kind of the dispute. But in my view, we should send the positive signal to comply with international law in the procedural matter. So we are always on the side of the country which has the intention to comply with international, that is very important.
We should be clear and,
Yeah.
and forceful about that.
Yes.
Yes, thank you. Peter, you want to comment on the U.S. record?
Well, if you were to ask almost anyone abroad, does the United States comply with its international legal obligations, the first most prominent example all of them would raise would be the conduct of the United States under the Vienna Convention on Consular Relations, because there you had a series of ICJ cases, and you had cases in the U.S. Supreme Court, and you had several executions that occurred in the course of that case decision-making that occurred. Let me make 2 points about that. One, if you are a foreign national and you are arrested in a country, you would rather be arrested in the United States by police anywhere in this country than anywhere else. The United States has done a very good job of educating federal, state, and local officials on what their obligations are towards foreign nationals when arrested. We are complying with the Vienna Convention. I can show you instruction books. I can show you little cards that are carried around by police all over this country. We are doing that job, and we are doing it well. Again, if you are a foreign national, you're better off being arrested here than in a lot of other places.
Don't get any ideas.
That's the one side. On the other hand, if you look back at the record of what happened in the ICJ and in the Supreme Court, it's a very complex issue that would take about 20 minutes to explain. But at the bottom, you can say that the ICJ wanted the United States internally to force the states that had convicted murderers to give them a second chance to argue their case as to whether they should be subjected to the death penalty. And in the event, the President of the United States, George Bush, issued an executive order that told the states to do that. But the Supreme Court said that doesn't do it. This is something that the states themselves determine, and only Congress is in a position to override that. Congress didn't do that. That's a function of our own federal-state situation. This is a question that you can debate and argue at some length. I do want to say that it is important to remember what strong state and local feeling you have about cases in which you've had really quite brutal situations occur. And so I don't necessarily say that I wouldn't have preferred that the governors of every state order a hearing. In fact, one governor did order a rehearing, and the same result came out of that hearing as had been reached before. So it isn't as though we had a total failure in the area, but it didn't play out the way the ICJ would have had, which would have been rehearing every case in which there had been a death penalty ordered. So I'll stop at that because it gets more complex if I go any further.
Okay, well, let's open it up. Who would like to comment or ask a question? Don't be shy. We've got, this is very...
My name is David Loudon. I'm an independent policy analyst. My question is for Professor Furuya. When you speak of neighboring countries maintaining a neutrality in a circumstance of territorial dispute, let's say China and the Philippines, how can such neutrality be mitigated or impacted by outcomes that restrictions might be detrimental to, in this case, let's say, for example, Japan? It may be control of the sea lanes, for example, or the decision of China, should they try to do so, to impose a tariff on Japanese goods bound to the Philippines. And so just your thoughts on that, please.
Yes. If a state, not Japan only, but other state want to be neutral, at that time the other targeted state has to take into account other factors. In this case, if Japan would like to be neutral, but China do not think Japan is neutral, because Japan has such a problem that you just mentioned, that we have to protect our sea lane, against China's attack or something. So in that case, the China believed that Japan would be on the side of Philippines on the territorial dispute. So even if Japan really want to be neutral, in that case, it's quite difficult to be neutral from the perspective of China. So I think, so in this situation, we have to, or the Japanese government have to say that we are on the side of the country which comply with international law, the objective international law. So there is no other consideration behind this decision. We support the international law itself, and the countries respect international law. That's a clear message, I think, to the China. So the Japan do not have any other behind consideration. We just want to resolve the conflict by international law. That is the important point I mentioned here. I hope this answers to your question.
Does that satisfy
It provides me enough insights, and I think Professor Fuller was very clear that without saying no, we're on the Philippine side, the indication is Japan would say we are on the decision-making. We will act in accordance with the decision-making process of the International Court of Justice. So I'm comfortable with that.
I have an ignorant question. The pending case is about jurisdiction, is it not?
No, it's both. That's the point.
Oh, that's the both. Okay.
Let me say a word about the case.
Yeah, please do.
Yes.
Every major international arbitration begins with a dispute over whether the tribunal has jurisdiction. Okay, whether it's an investor-state dispute in ICSID or this kind of a dispute. Okay. In this instance, the position paper that the Chinese issued in December 2014, which I would commend everyone to look at, that was 2 years after they rejected the Philippine request for arbitration. Why did they do it? Because they were obviously concerned that the tribunal was going to decide its jurisdiction whether they appeared or not. And the entity before which the Philippines have acted is the Permanent Court of Arbitration. The Chinese paper purports to address only procedural issues. But if you read paragraphs 4 to 7, it deals with the merits. And it summarizes briefly its position on the merits. But that's not what the paper is directed at. It's directed at the lack of jurisdiction of that tribunal. And what is the Chinese position? Briefly, it depends heavily on international legal arguments. There are really three. First, the limited scope of the Law of the Sea Convention, which does not allow for maritime delimitation. Second, bilateral agreements, most importantly the 1995 Chinese-Philippine Declaration and a series of other expert group meetings and international government statements that China argues commit both governments to resolve maritime issues through negotiations and exclude other means of resolution, such as a claim at arbitration. Third argument. In 2006, the Chinese declared under the Law of the Sea Convention that they would exclude maritime delimitation issues from the Convention's compulsory arbitration procedures. So the Chinese argue the Philippine position, if it were to prevail, would in effect override the 35 other declarations that have been made to exclude maritime delimitation. To be clear, I'm not endorsing the Chinese procedural defenses. My point is they're heavily rooted in traditional international legal arguments, and the analysis depends heavily on an analytical framework that's entirely familiar to international lawyers. To enter into the details of just one of the arguments, because it is worth doing so, the Chinese say, look, the Philippines have very cleverly presented this as a question of interpretation of the Law of the Sea Convention. That is what the Chinese call cunning packaging. In fact, what the issue is in the case is the delimitation of the maritime boundaries in the region, and as the Chinese say, that's outside the scope of the convention. Put another way, the Chinese say, the Philippines have the cart before the horse, and that's the language of their paper. Why? Because you can't figure out what rights exist in a maritime area until you figure out who owns it, and the ownership issue is not part of the convention. Again, I don't endorse these arguments. I simply point out they are very much international legal arguments, and they are not frivolous.
Philippines responded in
Oh, yeah, this is going on. There's even been, I think, a ruling. I'm not sure I've followed that closely, but I think there's been a jurisdictional ruling. Now, the question I'd ask my colleague here is, okay, so you get a ruling from a tribunal like this, and it says there's jurisdiction, and the Chinese ignore it, okay? How do you respond to that? What should be the response? Because that tribunal, if it holds that its jurisdiction, is going to go on and issue a ruling on the maritime rights and on the delimitation issues and so on. And at least one can imagine the Chinese saying, look, you can have anybody saying what it wants about these issues, but you have no authority to do this.
How do you think Japan and the United States, for that matter, should respond in this situation?
He's the political.
Well, yes, I think the both governments should support the arbitral proceedings, not the result of that. So if the arbitral tribunals admit jurisdiction, we have to send some message to support and the result. We don't know the result which is favorable to China or Philippines.
Well, let me just say, the United States itself has had quarrels with the jurisdiction of international tribunals. Yeah. See the Nicaragua case. Yeah. See the platforms case in the ICJ. I think we need to be very, and we ended up, because of the Nicaragua case, of withdrawing our submission to the ICJ. Yeah. So jurisdictional decisions which are not well reasoned have consequences, some of which are worse than whatever the tribunal achieves with its ruling. Yeah. So I'm at least one who is concerned about overreaching by tribunals. And I think it's at least worth pausing and saying, I'd like to take a very close look at the decision of that Court of Arbitration on this issue, because the precedent of jurisdictional reach by tribunals is something we, the United States, have to be very concerned about, and obviously Japan and other countries are too. This is a very sensitive subject, and I'm not yet at a point where I want to say that just because they rule they have jurisdiction, whatever they decide on the merits, I'm going to uphold. I'm not there yet.
My guess is, if they do say they have jurisdiction and China immediately says we reject this, there'll be huge pressure on the United States to do or say something immediately.
And we won't.
And then the Asians will say, well, are you with us or against us? But let me not talk anymore. Let's have some more questions and comments from all of you. Yes, in the back.
Sure. Aaron Webb. A lot of the biggest news stories of the past year have been, at their core, challenges to international law regimes, the emergence of ISIL, debates over the Arctic Circle and access to resources, the South China Sea issue that we've talked about, refugee flows in Europe, the Greek debt crisis, non-proliferation as it relates to Iran. Overall, how do you see the ability of the current set of world leaders to kind of meet all these challenges, to patch up previous regimes or replace them with new ones, when there are so many simultaneous challenges to kind of the basic tenets of world order? And I guess the question in this context is does the emergence of China give an opportunity to refresh some of these? Does treaties like TPP give an opportunity to refresh some of these ideas and introduce a new generation of leaders to kind of the big idea thinking necessary to revive some of these regimes?
I'm going to political science start first. I take the issues one at a time, it seems to me, but some of the developments that have occurred that you make mention of are, it seems to me, ones where China and a lot of other countries need to think hard about them. I regard, for example, what happened in Crimea as probably the best example I could give of a problem. I happened to be with a man named Oscar Schachter, who was a very beloved professor of international law at Columbia at the time of the Iraqi invasion of Kuwait. And we were in Australia together. And he basically said, sometimes you come to a point where you have no other resort but force. I find what is happening in Ukraine to be as concerning a development as anything, because it is in many ways different from disputes over who owns what. It is a clear step of of taking territory of another state and doing so without any legal foundation that anyone's been able to point to. So this is a very dangerous situation, and I think the answer may be in trying to politically resolve the dispute on the ground so you can get a dialogue over what happens in the long term. I mean, we're never going to recognize the acquisition of that property. As a young lawyer, I went to the Estonian legation in London because, of course, we never recognized the Baltic state seizures after World War II. I went to the Estonian legation to prove someone's marriage. Life went on in the Baltic states. You had to do that. So I see Crimea as a new Baltic state situation in which we will never recognize that, in which they will have enormous difficulty dealing with the world because of it. And I don't think we ought to let up on insisting that is simply not the way conduct in the international realm should occur. On all these other issues, I think you have to take them one at a time. I think that's the president's, the strongest part of the president's argument about why the Iran deal doesn't cover 9 other issues with Iran, which I'd love to resolve as well, is because you got to take issues one at a time. And sometimes you can't get all the other issues resolved. If you start down the path, though, of resolving some of the issues, you can have some reason to hope there might come a time when you could resolve others of the issues. And so that, to me, is a very strong argument that's been made, whatever other force of the debate we've had in this country. That particular point, I think, has been made very well and has been very persuasive with a number of people who've looked at it. So I don't want to take all those issues all at the same time. I want to deal with them one at a time, and some of them are not going to be easy.
So yes, I'm afraid I'm not qualified for answering such big issue at the same time. But very generally speaking, that the ordinary people expect to international law too much or nothing. So they sometimes expect the international law can settle all the dispute at the same time, but someone said international law is meaningless. But my answer is that the international law, in some field, very good tool to settle the dispute, but in other fields, it's not so effective. So, and speaking of the Chinese attitude of China, I think before China there is 2 ways to proceed. One is the way to positively comply with the international law, current international law, which has been established by the European and American countries. And the other way is that China changed the content of international or basic concept of international law. That is the other way. And in my understanding that more than 70 years ago, Japan tried to change the content of international law and failed. That the result of the war, very tragic war. So, in my view, we have to anchor China to the current international law, even if the content might be changing to respond to the attitude of China. But basically, we have to maintain the current concept of international law, which is basically the equality of countries. That is my opinion. And so that we have to make a clear attitude to support the country who respect the rules of international law.
Can I add one thing to that?
Yes, please.
At the core of everything that Roger Fisher wrote and taught was the notion that
law can only accomplish so much, which is your point. International law can only accomplish so much. And we need to remember every day that our own domestic law doesn't always work. And much of what Roger wrote about was so-called second-order compliance, in which the reason when law doesn't work in our society, that's where our courts come into the picture. So we shouldn't expect, as you just said, too much from international law.
My favorite Roger Fisher example is two people are fighting over an orange, and so you think, well, just cut the orange in half. But no, you find out that one person wants the peel for marmalade, the other person wants the fruit to eat, and you have to talk about it first. But I want to take a crack at that last question, because I think that's a very interesting one. As I understand it, do we have an opportunity to sort of refresh or reset commitments to world order? And my comment here, and I invite dissent, is that, you know, if you define respect for international law and international norms, peaceful norms, whether you call them 5 principles or ASEAN way or whatever, just stick with me for a moment. These things are carried out through institutions. And I think it's fair to say that the institutions in some cases have not caught up with changing reality. You had the original mistake of naming 5 countries to the UN Security Council, which has precluded Japan and India and so on from joining. But more recently, we have this issue of quota adjustments, voting power adjustments in the IMF and the Asian Development Bank. Legislation's been bottled up in the Congress since 2010, and guess what? The Chinese said, well, we'll just have our own bank. And then the U.S. made an incredibly foolish mistake, in my view, by trying to persuade others not to join the Asian Infrastructure Investment Bank, which I think was a self-inflicted wound, where we should have said, yes, let's get in there, let's fight for good governance. The Europeans and the Australians did. I hope, personally, Japan joins the AIIB. I mean, that's just one example, but if we don't adjust the institutions within which these norms occur, if we don't repeat the precedent of having a Chinese judge on the court, I mean, these are ways in which we can refresh or update commitment to world order. The threat to world order that scares me is not so much China, it's Russia. I think Russia really is trying to undermine what they see as the Western-dominated world order. The Chinese right wing will publish in Global Times, that international law is a Western plot, individual rights is a Western plot to weaken China. You get all this stuff from Global Times on the right, but the way they behave, I think, is much more careful and pragmatic. Whereas I really think Putin is a different person. That's generated.
Well, just to add to your one quick point, which is that your point about the changing circumstance and the need to adjust has been demonstrated this past week. The EU got together and came up with a very sensible rule to deal with the refugee problem. And the idea was you would register in the first country you landed in. That worked just fine when the flow of refugees was of a level and of a kind that each first recipient country could deal with it. They've still got that rule, but it no longer makes any sense at all, given what they're now facing with. And yet they're still staying with that rule. Institutions need to change, and sometimes they're going to have to change a lot faster than they're used to doing.
That's right. In the back.
Yeah, my name is Roger Cochetti. I work with companies in the technology sector. And I was wondering if the panel, the sort of side discussion about the Crimea was interesting, raising it to a level of sort of abstraction, which I think is important. If you listen to both Chinese and Russian nationalists, government and non-government, at the bottom of their reasoning is that international law is being used in a way that disadvantages them from a nationalist point of view. Both will point to the fact that during the 19th century, when international law was created by the Spanish, the French, and the English for the Western Hemisphere, the United States had no compunctions pushing it aside whenever it served their interest. And once the United States got its own and got control, then it said, stop, everything frozen, now we have to have international law. And they'll also point to the fact that there was a pile of treaties that Germany signed with numerous, quote, countries during World War II that were simply
washed away at the end of the war because they were viewed as invalid. These weren't real countries. So from both of their points of view, it's not that international law doesn't exist. It's more like you guys have exploited it, and now that you've gotten everything you want, then you're asking us to freeze in a weakened position. And they would use, as one did with me, the example of, okay, if we drug George Bush into signing an agreement to give away Texas, and then he signed an agreement, does that mean we have to freeze in place? Or if we captured the United States Senate and they ratified the treaty to give away Texas under duress, does that mean that Texas is gone? So their point of view is really quite different than anything the panel has discussed. I would be interested to hear how you react to that, because it's shared by hundreds of millions of Chinese and Russian people. It's the kind of way to look at it.
Who wants to be first on this one?
Again, going to specifics, if you were Russian and trying to defend what has happened in Crimea, you'd say, well, look, we're dealing with self-determination. You're the ones that advocated self-determination. These people want to be part of Russia. So we do have the dialogue in terms of that are familiar. It's just we don't like where it's being taken. And I take your point about the argument that's being made. I'm not very sympathetic with the notion that a world was created that had haves and have-nots, and the have-nots are the ones who are not prepared to live with the rules. I think I've shown that time and again it has served the interests of China to be part of the system and to push on its content. And I think that's the lesson we should be taking elsewhere. But I don't say it's easy. And if you look at particular areas, whether it be investment disputes in Latin America or the Crimea, you see real difficulty in making the rules work when others want to use it for a very different purpose.
Yeah. So I'd like to focus on another aspect you take that. If my understanding is correct, if my understanding is correct, you said after raising the United States, the international law is a little bit frozen. But I don't think so. That international law is every time international law is moving, and international law is dynamic process to be established. So every time there is the leading country which set up create a new international law. The problem is which country can be a leading country to norm setting, take a norm setting leadership. So in the past decades or more than last century, the United States, a leading country which established the new international law, that's the result. So we are living in the result of that international law norm setting. And after, in this 3 or 4 decades, Germany and the Japan and also the leading party or leading actor of norm setting. But now the China and the Russia are also the leading country to create a new international. The problem is to what extent China and Russia can involve in the creating process of new international law. And in response to this new process, how should we, Japan and the United States or other old leading countries, respond to this process? That is the very dynamic process. So as an international lawyer, I objectively look at the process, and I'm very interested in that process. But probably as a diplomat or the decision maker, it is quite uncomfortable situation.
Well, I've dealt occasionally with audiences. The U.S. version is quite different, but it's, we don't want other countries telling us what to do, and, it feeds into the Buy America argument and the Gatzilla, if you remember that. And I mean, one thing, going back to this idea of the national interest, you after all, leaders are elected because they're supposed to be doing good for their country and their people. So you really have to almost start with that, and you have to show why international law is good for you, the domestic audience. And one thing that people don't point out very often is that I'm thinking now of trade disputes in particular. Yes, it's true that we are obligated to do certain things depending on the finding of dispute settlement panels and so on. But this system also gives us a voice on what other people are doing that we didn't have before. I mean, it's mutual. It's not just we're victims of some foreign plot. We now have a voice and a legal means of bringing about change in another country. And the people, I think, have been a very poor record on the part of virtually all presidents of the U.S. in explaining more broadly what globalization does for the United States, why international trade rules have been extending further and further away from just narrow exports and quotas and so on, tariffs, and more broadly why strengthening international law is good for the United States. And that just has not been, no president has been willing to stake any credibility on that, with the partial exception of the very first month of Bill Clinton's presidency. He made a speech like that. But mostly the political advisors say, you want to waste your political capital on what? International law? You know, when you could have XYZ in the Congress. So there used to be a group called Members of Congress for Peace Through Law. I don't know if any of you remember this. And the senator I worked for worked with this group closely, and it believed very much in international law and the UN and the ICJ. And there's nothing like that now, but at least they tried to produce material to convince not only the public but fellow members of Congress that this was good for the United States as well as for the world. And I don't see that happening at all. Peter.
I want to segue into tomorrow. I took out of my talk the discussion of the Asian Infrastructure Investment Bank. The Post last Sunday quotes, in respect of the Lower Sesan 2 Dam, the Minister of Commerce of Cambodia, who says, Chinese are giving us money, and, quote, they're absolutely nothing, no conditions at all, unquote. There's a kind of reverse Gresham's law here of bad policy driving out good. Drop the demands on democratic values, drop the demands on transparency, and just give them the money and build. And I think we need to think about the world that creates.
On this, because I was somewhat involved from the outside, unsuccessfully trying to stop what turned out to be a policy mistake. But I have read the charter, the articles of agreement that have been negotiated, and they're a huge improvement. And they do, at the insistence of Australia, Britain, and so on, they do include a lot of these provisions, including certain procedures for certain kinds of loans and how they get decided. That's the AIIB, which is only a small portion, actually. I mean, it sounds like a lot, but it's only $100 billion out of the $9 trillion or so need. And let's not forget that China has been doling out money already, and so there's lots that's going to happen outside of the bank. So, you know, that's been going on for a long time. I personally think that when Chinese fishermen started getting shot in the upper Mekong, and when people were kidnapped, Chinese were abducted in the Middle East and so on, I think there's been a sort of an awakening that China itself has a stake in protecting its own citizens abroad through enforcement against trafficking, against corruption, and so on. But at the same time, the diplomatic advantages, you can just hear the debate in China, almost. The diplomatic advantages of moving in with no conditions to speak of is such a refreshing change for the Cambodian government, because the United States comes in and talks about corruption and human rights and all this kind of thing. So what are we going to do? Are we going to stay out of this game, or are we going to get into it? I think we should be in it, but I think it's going on. It's going to go on anyway outside of the AIIB. We haven't seen an AIIB loan at all yet.
And one question it asked is, do we have to address the issues that we think should be part of the dialogue in a different way in order to persuade countries that this is not illegitimate, that they're concerned with the things that the World Bank has insisted on? I mean, let's face it, there are developed countries that don't think that the IMF and the World Bank have all the knowledge in the world as to how to manage economies. Go talk to folks in Greece if you need any help with that. But the point is, on some of these core values and the willingness of the Chinese, seemingly, as this article in the Post documented, to just give the money and not ask questions, that's very troubling. And it's a bad money driving out good problem that we need to figure out how to respond to. And it isn't enough to just say, but you're overlooking all these good things we've said.
An interesting thing happened in Myanmar. The Chinese were going to fund this huge dam, and because the change of government meant that Myanmar didn't want to be in the pockets of the Chinese, they actually postponed the dam. Excuse me, somebody had your hand up. You did, and then you. Yeah.
The recent situation in Indonesia, where both China and Japan were vying for the contract to build a relatively small high-speed rail link between
Jakarta and Bandung.
And the government of Indonesia in the end said, no, we'll do it on our own, we'll do a smaller version. The Chinese then said, well, we'll give you loans, we'll give you loans to get this started. No interest loans, low interest loans. And the Indonesian government, surprisingly enough, said, no, we'll do it on our own. We'll do a smaller version. We'll do a low speed. We'll do something that we can afford. But I think what they're saying was we don't want to get in the middle of a brouhaha between Japan and China.
Yeah, they have awarded Japan a lot of coal-fired power plant and also something.
The issue on the high-speed rail link was that the Japanese were offering essentially an accident-free system, whereas the Chinese couldn't say that because of the number of wrecks they've had on their system.
Yeah,
so
there's
the
awareness
Indonesians
of safety. We're getting close to the end here, but there's a hand up over here. Yes, sure.
The South China Sea, and which is the proposal for the code of conduct between Asia and China. The China they have been discussing the proposal for more than 10 years or something. That makes me doubt there are still chances for them to sign it in the coming month or next year or something. So, from the viewpoint of the international rulemaking expert on the international rulemaking, what do you think they need to sign it in a very near future? Such as do you think they need any involvement in a third country or third party organization or something to make it happen? Thank you.
Yes, as you told that there have been the intensive discussion several times to conclude the legal binding code of conduct between the ASEAN countries and China, but unfortunately it failed so far. I think at present time is a new chance to conclude the code of conduct, because now the China, the Philippines instituted the arbitral tribunals, and the China has some option, so completely neglect the arbitral proceedings, or participate in this procedure, or just expressing the legal argument or legal opinion on this matter. But if I'm a leader of China, I propose to create a new code of conduct, and that eventually settle the dispute between China and the Philippines. So this might be a good idea as a diplomat.
Starting bilaterally, you mean, and building into a binding code.
Yeah.
That's interesting.
I would think that whatever agreement you're going to get has to focus on, are we trying to resolve the issues for all time, or are we trying to just for the moment preserve the status quo in a peaceful circumstance? And secondly, are we trying to deal with all the issues or only some of the issues? seems to me one ought to sort of take the issues apart. That is, there are maritime rights, there are passage rights, there are fisheries rights, there are mineral rights. After all, when you find minerals, you get agreement on a joint sharing agreement. And everybody wants to get the oil out of the ground, okay, at least when the oil prices were up. So there are some, to me, sort of preserving the status quo, breaking the issues up, and looking at possibly finding agreement on how we are going to, in the long run, resolve this process for future resolution. Those are the challenges. Now, how you negotiate that is tough, and I'm not saying any one of this is going to be easy. But for me, I don't like the idea of pushing fishing vessels out of waters with military vessels. Things can go wrong. And so to me, sort of freezing the status quo and leaving the dispute as something to be resolved would be the first objective, and I then work from there on specific issues, because I think there are real differences between the minerals.
Declaration on the behavior of parties and
exactly, and work out from there. Yeah.
And you would start bilaterally and build that way.
Yeah.
Two great ideas. We're reaching the magic hour where we're going to adjourn. Is there any last-minute question? Or if not, I'm going to ask both our speakers if they have any final comments, anything that wasn't covered, anything they wanted to say. Please.
I think the case of AIIB and the Code of Conduct are of the same issue. That is what I mentioned, that whether the China can be a leading country to set up the new international law. So I think the establishment of AIIB is one of the example of the China's attempt to setting the new rules in the field of international economic law or international development assistance. So I think the next one might be the Code of Conduct in the South China Sea. And I'm not sure whether the Chinese government actually try to establish or make such a code of conduct. But as I told you, if I were the leader of China, I try to do that. That is really the new rule, which applied within the Asian Pacific region.
Take a chance to invent a new approach. Take a lead.
I close with a very different thought, which is I'm struck by the fact that none of the issues that we've discussed this morning has ever emerged in the great presidential debate we're having right now. None of the issues that we've discussed this morning, with very few exceptions, have passed through the lips of any of the president or any of our other senior leaders in the government. We need a renewed concentration in this country of thinking about these issues. And we have a very different world from the world that most Americans think they have. I give my favorite example of that is I don't think Americans begin to understand what the NATO agreement commits the United States to do in Europe. And we ought to think very hard about what we need to be doing to be certain that, as Tip O'Neill said, all politics is local, and we don't have the local understanding that we need to address a number of the issues we've raised this morning. So I, for one, would urge a greater concentration of thought leaders in this country and political leaders on some of these issues so the American people understand them. Because if you don't have a domestic population that understands where you're going, I think you have problems.
Note, I'd like to ask you to thank our two speakers for an outstanding